Good afternoon, everyone. My name is Yahya Dardashti. I'm one of the PICRA board member and also one of the co-founder of PICRA. Today, I have the pleasure of talking to Mr. Shub on behalf of PICRA. Mr. Shub has been a lawyer for the last 43 years. Mr. Shub has served as a real estate lawyer in Toronto area, supervising and processing more than 60,000 residential real estate closings. As a graduate of Osgoode Law School class of 1972, Stephen was called to the bar in 1974 and began practicing to the bar in 1974. And started 1992, he began his existing law practice as Stephen H. Shub Professional Corporation, currently located in Richmond Hill area with 7 locations and over 40 staff, and continue to dedicate his time to serving the diverse needs of the Toronto real estate market. His reputation as a reliable and accessible expert 7 days a week in Toronto real estate industry has helped thousands of Canadians achieve their real estate goals. I've had the pleasure of working with Mr. Shub for the last 19 years myself. Before I hand over to Mr. Shub, I must also add that today's seminar was sponsored by Mrs. Kathy Sanaye. She does small claim courts and tenant and landlord legal services. Mr. Shub, please, I hand over to you.
Thank you. Yeah. You make me feel so old.
We are ready to hear for what you have to say regarding will. I know in the Iranian community, this is a very complicated subject for all of us, especially for those of us who are more new in Canada and
Menu.
to know
in any
more
event,
about this subject.
I'm not sure if am I, sorry, say again? Okay, so am I okay to proceed?
Yes, sir.
Okay, so currently, actually, we're expanding our 7 offices to 11 in the GTA, by the way. And testament. So a paper 2-page will request form, which can be emailed to us. And the fee that we typically charge for a package, which includes the will, the power of attorney, and the accompanying affidavit, is $285. Now, remember that it doesn't matter who you are, how old you are, what assets you own. Because you do a will today doesn't mean you can't change it tomorrow. When we do a will in our office, we focus on a formula for distribution of whatever you might own anywhere in the world. If a person's in their 90s, they might want to leave specific items to specific beneficiaries. So, for example, if a person's near the end of their life, they might say, look, whatever house I own at the time I pass, I want to leave to so-and-so. Whatever car I own at the time I go, I might leave to so-and-so. But typically, if a person's making a will and they're not in their 90s, and it's unpredictable as to whether or not they're going to end up
Mr. Shab, apparently your internet in the office is either slow or something is interrupting your internet. Uh, can we please disconnect you and come back to you again?
Owning $1 to happen with her asset in my will to my husband. And if both are gone, for example, in a common accident, everything to the children equally. That
I'm sorry, everyone. I think we have a problem with internet. We will get back to you momentarily.
that's a very is the person to a second marriage is one. Yeah, is the problem at my end or what end is the problem? Do you know?
I believe it's your end, Mr. Shab.
You think it's my end? Do we keep cutting out?
Yes, it is okay now. Do you want to continue, Mr. Shab?
Distribution of assets, whatever you own anywhere in the world. However, even though you might have such a will, for example, if you have assets sitting in Iran, then the law of Iran might dictate what happens to your assets in Iran. But remember, our will still will cover whatever assets you own at the time of passing anywhere in the world, but we cannot tell.
Mr.
Another
Shab,
country.
off
Also,
again.
Ontario law is such that a will made prior to marriage
Mr. Shab, we don't have you on the system. I think your internet is having a problem.
is invalid. Husband and wife make it to everything to home office. I would be very surprised if it's my end, actually. What does Amir say? Does Amir indicate that?
You are good now. Please go ahead.
Okay, so I just want to repeat what I just said in case you didn't catch it. In Ontario, if you make a will prior to marriage, that marriage will invalidate the will made before the marriage. So, for example, if you have a situation, and we've had situations like this, where a husband and wife do wills, where husband leaves everything to wife, wife everything to the husband. If both are gone, for example, in a common accident, to the children. Then the wife passes. A couple of years later, the husband remarries. Now, when he remarries, he thinks, well, the will I made before marriage was fine because it said in that will that if my first wife would predecease me, everything would go to my children equally. But a lot of people don't realize that when they got married in the second marriage, then that will made prior to that date is going to be invalid. And so now if he passes after having married a second person, then he dies without a will. And what are the rules in Ontario once he dies without a will? The rules in Ontario are that if you die without a will, then your current wife, second wife in this case, would get the first $200,000 in assets, and any remainder would be divided depending on children. So, for example, the remainder, if there's one child, would be 50-50, 50% to the new wife and 50% to the child. Whether that child's a former child or of the former marriage or not, doesn't matter. So if there's more than one child, then 50% would go, one third would go to the wife after the first $200,000, and the balance would be divided equally amongst the children. So again, the idea is that if you do get married and you've made a will prior to marriage, watch out, be careful, make sure that you redo your will after you get married. Don't assume that the will made prior to marriage is still valid in Ontario, because it is not. Recently, I had the occasion to do a will for somebody where it was a similar situation to that, except he says, look, I plan on marrying this lady that I'm currently with. And so we put a clause into the will prior to marriage that will was being made in contemplation of the marriage, the future marriage. When you do that, then that will actually survive the new marriage. So as long as you put a line in the will saying, look, I'm making this will in contemplation of a future marriage to so-and-so, then even when they do get married in the future, then that will still maintain its validity, okay? But normally people don't think about that. Normally they just think, oh, my will prior to marriage is still good, but it's not. Also keep in mind that when we do wills, we also normally do what's called a continuing or enduring power of attorney. So remember that any power of attorney dies with death. So even if you're doing a power of attorney for a real estate deal, if that person becomes deceased, the power of attorney ends. We have cases where a person says, a son or a daughter says, look, selling the property, I have a power of attorney for my mom or dad. Okay, let me have a copy of the power of attorney. Let's look at the photo ID of the mom or dad. And by the way, where is the mom or dad who gave you the power of attorney? Like, the lawyer wants to know, is that person still alive? Because although they might have given a power of attorney 3 or 4 years ago to the son or daughter, remember that power of attorney ends with death. So we have to confirm, the lawyer would have to confirm the person who gave the power of attorney is still alive and well. They might be incapacitated. So typically the powers of attorney that we deal with in our office, we normally recommend that the power of attorney cover both medical matters and property matters. We roll them into one power of attorney. You can't have two powers of attorney, one strictly for medical matters and one for property. But most of the time, people want a certain person to have, a trusted person to have the power of attorney, and son or daughter, whoever it might be, a spouse. And so we then make sure that we accommodate that need and make it simple and roll them into one power of attorney. However, typically, to avoid abuse, because remember, sometimes you give a power of attorney to somebody and you don't want them abusing the privilege of having a power of attorney. And while, for example, a mom or dad is still alive and well and healthy and capable of making decisions on their own, we don't want, again, any kind of abuse related to that power of attorney. So we typically put a clause in our powers of attorney that say that If there's a serious illness or accident, not resulting in death, but resulting in a physical or mental incapacity, then before the power of attorney can be used, the attending physician, because typically there will be an attending doctor the minute there's a physical or mental incapacity. So the attending physician would have to confirm on his letterhead that there's need for the use of a power of attorney before it can be used. So we have a little bit of a protection, a little bit of a barrier, so that the power of attorney is not going to be used. It's only going to be used in a legitimate situation where there's a need for the power of attorney. Okay, and again, typically that power of attorney will cover both property matters and medical decisions. And when it comes to wills, we see too many situations where a son or a daughter is communicating with our office. And the problem is the Law Society has warned lawyers, take care. There's too many sons and daughters who are sometimes trying to manipulate a mom or a dad and maybe get some kind of unfair advantage. So one of the things we look for when we do a will is, okay, who are all the sons and daughters, and is what mom or dad doing, is it reasonable? Are they taking into account all their children? If for any reason a parent, a mom or a dad says, look, I'm not really interested in leaving assets of any substance to a son or daughter, then we're going to ask why, and we're going to make a note of that. And we're going to say, well, we should still make reference to that son or daughter in the will. And you should still give that son or daughter at least a nominal amount, $100, $1,000, whatever it might be, in order to indicate when the will is dealt with later after death that the deceased did not forget about that son or daughter, that there was no undue influence, that particular person who gave the will or did the will had in mind that son or daughter, and there was a reason that perhaps during lifetime you've already given that son or daughter substantial assets. So keep that in mind for the future. So basically, I'm going to open up things to questions, but before I do, I just want to remind you that if you're considering doing a will, go into our website called Will, W-I-L-L, Planning, Planning, Ontario.ca. It takes 5 minutes to read it over. There's a 2-page will request form that you can fill out. You have to fill out one for each person. For example, as a husband and wife, each one would have to fill out a form. In that form, we don't look at any assets. We're not interested in what you own. We're interested in, again, a formula for distribution of whatever you might own, because assets are going to change from time to time, and no one can predict the future. Also be aware when it comes to residential real estate, we currently have 7 offices in the GTA. We're now growing to 11. Next couple of months, we'll have 4 more offices. And we have substantial staff. And typically, if there's any questions, evenings, weekends, don't be afraid. My direct dial, good to 11 p.m. 7 days, is 416-520-6120. So I'm happy to entertain your questions. Hopefully I can answer all your questions. So can we proceed with questions?
The first question, if you may, come from myself. I'd like to know at what age, I know there is no age, but what age do you think one should come to you and prepare a will for himself? Also, another question I have is, if somebody has children under 18 and 2-3 years later the children are grown up and they are adult, should he come back to you and change the will again?
Okay, so normally what we recommend is that anybody over the age of 18 should entertain a will, because remember, if you do a formula for distribution of whatever assets you own, whether you own $1 today and $1 million down the road isn't relevant. Like, we don't care what a person owns. So as their assets evolve, as their assets change, no matter how old they are, basically you've covered a formula for distribution. So normally when we do wills, we do them in such a manner that as long as that formula doesn't change, then they don't have to change their will. For example, husband leaves everything to wife in his will. A wife might leave everything to husband. But then it might say, well, both of us are gone, common accident, whatever, to the children equally. Now, if those children are underage, because normally we say until age 21, money can be used for education, health, and welfare of the child or children. So whoever the trustee, executor is of the estate would be holding anybody under age 21. Now, you can choose any age you want. You don't have to choose age 21. Some people want age 25. It all depends on your children, how mature your children are, and so on. So, and then it might say, well, and it does say automatically in our wills that if a child should predecease you or not reach that age of 21, but end up with a grandchild, then that child's share who might have died along the way or predeceased, if that child had children, like grandchildren of the original person making the will, then it would be in trust for the grandchildren. So that things are set up in a sort of a broad way in the will to accommodate changes. A person might have one child today, but if you say, look, I leave to my children equally, well, if they end up with 3 children, you don't have to change the will every time you have a child. So I hope that answers your questions, Yaya.
Yeah. Let me see if any of my colleagues have any questions. We'll be happy if you could please type in your questions. So while we have Mr. Shub on board, he can answer any questions you may have.
Now, do you have any idea, Yaya, why the internet reception rate now is stable and why it wasn't before?
I have absolutely no idea. I don't know what happened at the beginning. You were cutting off and you were very slow. Your internet was very slow, but it's okay now. Okay, well, I don't see.
Okay, there's a question about a matrimonial home going to a spouse automatically if one spouse dies. Now, keep in mind that the question is a matrimonial home owned jointly by husband and wife? If the matrimonial home is owned jointly by husband and wife and one dies, then you have the automatic right of survivorship. So from a real estate point of view, all we need is a funeral director's statement of death, and we can do a survivorship. And typically in our office, we charge anywhere from $275 to $325 in that range, very nominal, to do a survivorship. And to register the survivorship application, land registry office is $77.62. So it's a minimal charge and easy to do, right? If the couple own jointly and one passes. But if only one spouse is the owner of the matrimonial home, then the problem is, the question was, well, does the matrimonial home automatically go to the spouse? The answer is no. That spouse might have a right to live in that property for a period of time, but the difficulty is that it's an asset. And remember that a matrimonial home is owned 50-50 typically. And so if then you have to get into doing a probate, and you have to proceed, assuming if there's a will, you're going to do a probate. And I warn you now in Toronto, if a person dies in Toronto, the probate application procedure, appointment of a state trustee, can take 6, 7, 8 months. Recently, I had a family member who passed away, and she lived on the north side of Steeles in York Region. So it was very quick. The probate procedure through the probate office in Newmarket only was about a month. Whereas if a person would have died living south of Steeles, you're talking 6 to 8 months. Any other questions?
So, Mr. Shub, in the question you just answered, what happens if the home is not matrimonial? It's an investment property. One spouse dies, and there is no will anywhere. So, what happens there?
Well, if there's no will, then typically the next of kin, being a surviving spouse, for example, would apply to be appointed as the estate trustee, and then would be required to distribute assets and pay debts. Like, first thing is you inventory the assets of the estate, not just that investment property, but what were all the assets owned by the deceased at the time of death. That's point number one. And then point number two is you have to end up paying debts from those assets. And you might have to liquidate some of those debts to pay, some of those assets rather, to pay debts. And then the next question is, well, okay, once you've done that, then how do you deal with the distribution if there was no will? Well, typically the distribution would be wife would take a preferential share in Ontario of $200,000. And then next question is, well, are there children? If there's only one child, then the law in Ontario says that the wife would get 50% of the remainder and the child the other 50%. If there's more than one child, the wife would get 1/3 after the first 200,000, and the balance of 2/3 would be split equally amongst the children. And that's how it works.
And how about if there is a mortgage on the property?
Well, again, the mortgage is like debts, right? So, typically they would sell a property in order to get rid of the mortgage, pay off the mortgage, and then use the assets to distribute amongst next of kin.
I see. So
there's a question from Simon. Two owners bought a property, not married, but they're living together 4 years. Both have kids from a previous marriage. Now, one of the owners passes away. What happens to her share? So remember, first of all, if each one is officially single, because common law, when it comes to real estate, common law relationship has no meaning, no significance. Like, you could be common law for 10 years with 3 children of that relationship, and it's not a matrimonial home. It only becomes a matrimonial home if you're officially married to each other. Okay, so understand that part. So again, the scenario was 2 owners bought a property. They're not married. I'm assuming each one is single. They're living together, common law, 4 years. But they both have kids of a prior marriage. Now, one owner passes away. So the first question is, those 2 owners who bought a property, did they own jointly or not? Did they not own jointly? If they own jointly, then remember, right of survivorship occurs. So if they own jointly, the survivor becomes the sole owner. If they didn't own jointly, if they each had 50-50, not joint, which is called tenants in common, then each one, assuming each one has a will, would simply leave, well, the person who passed away would leave her half interest as one of her assets in her will to whoever she wanted, maybe her children or whatever. So I hope that answers your question. If it doesn't, then simply ask another question or simply call me. Any other question?
I think, Mr. Shub, there was one question before that, or was it just Steaming?
Do you have any idea how many people are attending this get-together?
Amir would tell us later. I don't see it now.
Well, don't forget, if there are questions that come across your mind later after this get-together, don't be afraid to give me a call. Again, my phone number is 416-520-6120. My name is Steve. Evenings, weekends, I'm always happy to talk to whoever wants to call me.
Well, thank you very, very much, Mr. Shub, for taking the time today to come and talk to us. It was definitely very useful. Once again, I would like to thank Mrs. Kathy Sanaye for sponsoring this webinar. And don't forget, she does small claim courts, tenant and landlord paralegal. Thank you again, Mr. Shub.
Thanks a lot. Have a nice evening.
Thank you for watching.
Okay, bye-bye.
Thank you. Bye.